Okay. So we're online. This is Family Law. It's February 28th, the last day of February of 2017. And today we're going to back up just a little bit to um, property division in family court cases, okay, and spouse and divorces. So I need to pull out a few numbers. Do you have the numbers in front of you by any chance where you can, that way I don't have to flip between these screens. So how do you go about doing a property division? By the way, there's only one other of us in class here. Me and William are here. So thank you for all for joining us online, because I think there's like 5 or 6 of you online. Do you have them in front of you?
Yeah, I do.
That I gave you? Okay, I'm just going to put these in. So what you do really to come up with a number, this is from the homework assignment, you would actually put things in like a home, and then you would give the value. I'm using a spreadsheet, by the way. I know it's scary. And I would put the debt. I'd actually probably make that a negative because it's actually not worth anything. It's actually worth less. And I need to put a negative. Okay, there we go. And then I'm not gonna do all of them, but I'm gonna do a couple of them. Jeep. Okay, that one. We need to determine the value. I hope everyone thinks that or knows where you go find the value of vehicles. Okay, this is not a law subject really, but how do you find the value of a Jeep Grand Cherokee?
Yeah, Kelly's Blue Book.
You go like kbb.com or someplace like that. Like the Blue Book is the classic way to find a vehicle. Let's say, what's a 2013 Jeep worth? Do you have a general idea? You might have written it somewhere, but
It was like 13,000 or something.
Let's go with 13,000. Okay, we owe some money on it. Or do we owe money on it? Yeah. And we own a loan on Jeep. And it would be a negative. I think I gave you that loan number, 7,800. So hopefully it's worth more than that. That's not always true, actually. Thunderbird. Do you know where to find an older car value?
Search for a while.
Well, there actually are some of those sites will actually let you do older ones. So I don't know what, it's actually worth like a little bit more than you'd think because it's now an antique. Okay, so just giving you a little bit of idea. Let's say I own 3.2 acres of flat land. Where would I get that value? This is a thought. Where would you go to look that up? Okay, realize I'm not going to give you in this assignment an actual person. I could have, if I could have found that amount of property, I probably could have looked it up and given you and had to go look for the exact value. But where do you go to do that? Actually go get a value for property. You might get an appraisal. Okay, that's the first way. It's expensive though. There's an easier way than that. It's available online, especially in some counties. You'd go to and if this is in Wood County, West Virginia, you go to the Wood County assessor, has a tax value. They're going to give you a market value and a tax value. And what you're going to do is then come up with what is that worth in Wood County, depending on where it is. But let's assume it's out in the country a little bit, not too far on the highway, so it's not landlocked. It'd be worth about $25,000. Depends on how much road frontage and all that. But probably in a marital division like this, you would know where that property was, and you would be able to figure out, the exact property name or whatever. Okay, so and know where you can look it right up, and you would agree probably roughly to the cost. And if you couldn't agree, then you might get an appraiser involved. But realize you're going to have to spend, I don't know what appraisals cost now. You don't want for a mortgage. I think they've gone way up, like over $500 a pop now. It used to be you get one. We used to have what are called drive-by appraisals, which meant you didn't really do a lot of calculations, but you kind of would look and see in this neighborhood these houses sell for about $100,000. That house is 1,500 square, like 1,500 square foot, and the house is about that size. That's a little bigger than the area, and the appraiser used to just throw out a number. So that's not, they would just give you one. Nowadays, because there was like all this rampant fraud during the before the mortgage crisis and all that, right? Now appraisals are like way more expensive because now they have to be more detailed, and they go in and measure all your rooms, make sure you got paint on the walls and all kind of crap like that. Anyway, that's just fun stuff like that. Okay, I just want to throw that out to you. Okay. I didn't make this clear, but Marshall's student loan. Let's assume Marshall got his student loan before they got married. And I do see lily pad and marshmallow, so you do know who I was referring to. I actually went to high school with Ted, the guy that played Ted on How I Met Your Mother. Yes, I met Ted. His sister and my sister were good friends, actually.
Teddy Bear Ted.
No, not that Ted. Ted from How I Met Your Mother. Anyway, so that is interesting tidbit of knowledge, I suppose. Okay, let's go with, I'm putting them all in, I guess. Savings account had 12,000. Checking had 3,200. Who knows if these are just made up numbers, by the way. Credit card debt, that's 28,000. Life insurance from Lily's dad. Actually, that should have been Marshall's dad, but is what it is. Lawyered, right? Okay, that's one of my favorite lines. Anyway, okay, so we'll go on with the rest of that. How do you determine the value? I'll also give you grandmother's fine china, Marshall's grandmother, and the car accident litigation, which are harder values to get. So let's assume we have all these numbers and all these values and we've agreed on them. So that's the first step in doing a property division, is coming up with all the numbers. So one of the keys that you always want to have here is you want to have a total. So you put in sum, and then you're going to take all these numbers. This is in BTEC 275, right?
The student loan and the credit card debt, those are negative, aren't they?
Yeah, good point. I can change them in a second if I can figure out how to sum these. There we go. So we know what it's worth approximately, except for now I got to put negative 65,000. I'm sorry to be doing this in this fashion, but what was the other one? Credit card debt. So if you calculate that out, you see that the total value of the property of these two people is 23,500 or 235,200. Let's go with that. And you figure out, how would you do an equal division? Well, you would basically just take this number and divide it by 2 and go, bam, everybody gets $117,600, right? But practically speaking, how do you actually do it? So this is where it gets easier in some ways, but if everything was cash, so I took all this property and I just made it all cash, okay, a lot of it is, but some of it's not. I just make it all cash. It's easy just to write a check. Let's say it's all in the checking account. We have Marshall go down to the bank or Lily go down to the bank, write a check for $117,600 and walk out the door, and they hand it off, and bam, marriage property division's over. We move on, right? Is it really that easy? No, right? What we would then do is we would take and have 2 columns, really, Marshall and Lily, and we're going to say some of them, and then we wouldn't need family lawyers. No, that's not true. We wouldn't need accountants. You still need the family lawyer. This is the easy part of a divorce, by the way. You would just calculate out, like, well, who gets which thing, and try to make it roughly worth the same. So here's my first thing. I always go here, and I'm going to put sum in, and you should have some, I hope you have some Excel knowledge, but I'm going to just sum that entire column. so that I keep in mind as I'm going through. Somewhere here, if I pull out this, make this screen a little bigger, I can hit that little button with the little sigma, and it'll automatically sum whatever, it'll put the formula in for me. Okay, I'm just going to pump it in. All right. So then, I know this is Excel class, but here we are. Getting along fun. We would go and say, well, let's say Lily gets to keep the house. She really liked it better than he did anyway. So I'm going to put that she gets the house. Okay. And the Jeep really was hers and not his. Okay. So I'm going to give her the debt associated with it too, because if she gets the house, she also gets the debt. Okay. Makes sense? I'm going to give her the Jeep. And I'm going to give her the debt associated with the Jeep because that was basically her. I mean, if you get the asset, you get the debt. Okay, that's the way it goes. I'm going to give him the Ford. It's funny just to call a Thunderbird a Ford, right? But there's no debt with that. Okay, so right now we see a pretty big drastic difference between these two people's parties. So what are we going to do now? We're going to look and say, geez, if I give Marshall the land, then we're getting closer, right? Getting closer now. But then I got to give Marshall the student loan debt, right? But if I tell you, and we pretty much assume that your student loan is your own and not really a marital debt, right? Shouldn't that be not on the table at all for this calculation?
No, it should be primarily.
It's his debt, not a marital debt. It's his debt. So we disregard that. What we might calculate back in, and I didn't get so complicated as this in this assignment, is how much of their income during the course of their marriage went down to make that what used to be $80,000 student loan debt now into $65,000 student loan debt, right? So what I'm going to do is say his student loan's there, but that's out of that total now because it's not marital property. Okay, it doesn't get divided because it's not marital property. That makes it a little bit different, doesn't it? So at least now we're not going to have a negative $65,000 on his column. I think it makes sense to give Marshall his own 401k. Okay, so I'm going to give him the $82,000. The bummer is then Lily's going to get her 401k, right? Hers is worth more. Why would I just want to give each other the 401ks that were their own? Any reason you guys can think of?
That would cause conflicts with taxes and.
You got it. It's easy just to leave them in their own names, first of all.
Yeah.
And if you switch, if you just say, okay, Marshall, I'm going to take your 401k and I'm going to give 41,000 of that 82,000 to Lily, and Lily, I'm going to take the 97,000. I'm going to split it in half and give half to Marshall. That sounds good if it's just numbers, but if it's an insurance or if it's an investment account or a retirement account, what's the problem? The problem with the retirement account is that you can't get it tax-free or without paying a penalty until you hit a certain age. So you have early withdrawal penalties, you have taxes, you have those issues. So how do you really split the 82,000, the 97,000 until later? You can't. Well, here's the other problem with the later, is that truly you're not getting half of 82,000, you're actually getting the piece of that is part of the marital property, which is only the time frame from the time you got married to the date of separation, that you've put money into it. You only get that interest, and you only get that interest and then how it grows until you hit a proper withdrawal time. Okay? So let's assume then they're going to continue being employed and putting money into their 401ks. So there's going to be additional contributions that are not marital property, right? So let's assume they're 45 years old, it's still another 20 years till they retire. When they hit age 65, those accounts are probably going to be worth, hopefully, quite a bit more, right? For a combination of reasons. Does that mean that now let's say Lily's not 401k goes from 97,000 to 500,000 in the next 20 years? She's hoping it goes to 1.5 million or 2 million, I would guess. But let's assume that's what happens. It goes up to 500,000. Does Marshall then at retirement age get half of 500,000? No, because it grew for two reasons. One, interest and dividends, and her new contributions. He only gets to share in his portion, or his marital portion, of the growth that occurs over from the time of separation until retirement. Okay, so I didn't even tell you all that. Let's kind of forget about that. Let's just leave it in their own court and see if we can come up with a solution that doesn't involve that. By the way, in order to obtain those interest in the retirement accounts, we do something called a qualified domestic relations order. You remember talking about that? A quadro is a fancy way of saying it. Okay, a quadro is a specialized order that goes to a benefits administrator or a retirement account pension plan administrator that we sign by the court, and it has specialized language that splits up all these things and says, from the time we got married, let's say March 1st of 2008 until March 1st of 2017, that was our marital property time. So all the contributions that go in there and all the growth and everything, the value that is created during that time, you get that percentage of that time, okay, to split. See why that gets all complicated. So we're going to try to avoid that. I don't know if we can, but let's look. We have a savings account. They both get half of that. That's easy, right? Why is savings account easy? Because it's just cash. We just split it. Oops, I better give it half. Thank you. That's a tough math. 3,200. Oh, I got that one. That was the harder one. Okay, so you see where we're headed here? Okay, then we have credit card debt, and it's cash too. Let's assume that it's all on one card. What do we do? And let me see. What do we do with the? There's like 5 or 6 online. What do we do with the credit card debt? Basically, we just split it in half because it's still cash.
But if they're not equal, can you attribute the credit card debt to just one party?
Absolutely. Any of these items you can split, because that's why we don't call it equal distribution. We call it equitable distribution, because property has different factors to it. But if it's uneven, maybe we would just give one or the other. So let's keep going and do our calculation. What's half of that? I should have done easier numbers. 10, 20, 16. Wait, is that right? No, heck, that's way too much. 12, 5, 13, 14,000. Bam. Thank you, Tara. I did it on my own, and I put it in the wrong column. Okay. What is that? What was that? Debt? Oh, CC debt. Now, if it was on different cards, it would be easy to split it up between the different cards, right? Understand those things. And the final item is there's life insurance proceeds that they obtained during their marriage, but they came from Lily's dad dying. Is that marital property? No, it's not marital property. It's not marital property, so it isn't included in this equalization. So now what we have to do is figure out what is the difference in the two. Who is getting more? Are they equal? If these two numbers are equal, that's easy, right? So what do? We do an equal sign. We do Marshall's minus Lily's, and oh man, what'd I do? I made a circular reference. Ah, son of a gun. I should have known. Circular. I'm always bad at that. But see, that's because I did that sum before I put all the numbers in. I can't calculate the calculation. Okay, so I got that. I find out that we basically have a gap that Marshall is now getting about $35,000, $36,000 less than Lily in the deal. Okay, one of the first things we can do that William mentioned is we give her all the credit card debt. Okay, that was easy. Now it's a $7,400 difference. How do we get the rest of the way there? How do we get to 7,400?
Take the savings and checking, or a combination of either or, and assign it just to Marshall.
True. So what we could do is just say Marshall gets the savings account, right? Now we're at 1,400, and we only give him. This starts to get complicated, I think. Oh wait, I can't do that yet. Subtract that. What was that supposed to be? 1,500. Okay. We take that away from her. Oh, now he gets too much. Right? Is that right? Did I do that right? But you see now, we can get to the differences. Basically now Marshall's got 4,600, and that's true. Lily did run up the credit card debt, not Marshall on the show. So, I mean, it should be her debt, right? She should have to worry about it. She was a shopaholic. And so now what we end up with is some point we could split the checking and the savings account, right? But we need to match up and just match it up. I'm not going to play with any of the difference. Let's say we don't have cash remaining at the end in terms of the marital property. This difference would be, in this case, let's say let's go back to where,
A quick question.
yep.
If it is not equitable at the end, you do something like you mentioned on the test. I think it was like a equalization
An
payment.
equalization payment. Right. Okay, good question. That's exactly right. So what we're saying here is that I put the savings in the check, or I took first savings away. Okay, screwed that up. Let's say that we're at $7,400, that she gets $7,400 more than he does, and let's assume those two items aren't checking and savings accounts. Those are easy because they're dollars. We can just easily switch those around and give him half or whatever, or give him more than half of those. Let's say we can't. So let's say there's some other asset that's not liquid. Okay, that $7,400 difference where Lily owes Marshall in order to make up the difference, we would actually create an equalization payment. And what is the equalization payment? To get them to even, you would actually do half of the difference. And that would be your equalization payment, where she could just write a check for $3,700 and it's over. Now it's equal. Okay? Does that make sense? So I showed you all that to show you why you took VTech 275, even if you hated it, was you should have learned how to at least run a spreadsheet enough to get that done, right? You didn't learn it, but tough luck. That's what happens sometimes, right? Okay, so does everybody follow that? I hope so. That's what an equalization payment is then. Okay? Get it? Got it? Good. All right. So, oh crap, there's stuff, bombs going on. All right, so let's go a little bit. Something I assigned you to do before you took the test was read the Brooke B case, right? I switched to something else. So let me bring it. We see you, Tara. Oh, now they see you. Oops. What was I doing? There it is. Share to everyone. Okay. So now I'm bringing up the Brooke B case. So what's going on? Brian says hi to you all. He's a nice guy. He's an active chatter on the side, I noticed. So I asked you to read the Brooke B case, which you probably should do, right? And there's a couple big pieces to it that I think are important that I wanted you to read it for. So let's talk about that. What is it? What's going on in this case? What? There's a psychological parent involved, right? Is this an odd case? Do you find this to be a bit unique in terms of what circumstances you would frequently see?
Yeah, it's a little weird.
Yeah, so what happens?
Donald is arrested on some charge. I think it was something about taxes or something.
Some kind of white collar crime, right? Some money crime.
But Brooke had lived with the child basically all the child's life. Biological mother was in no way involved. You know, the child only saw her, once or twice or whatever.
When she was young, even,
Yeah.
right?
So Brooke wants, since Donald is being incarcerated, Brooke wants the primary legal custody for the child.
Okay, so that's going all right. So Brooke is involved here because she wants custody of the kid, right? But didn't she already have the custody? She did, right? I mean, she was raising the guy. Her and Donald were dating for a period of time, living together, it sounds like, and then they broke up. But the daughter stayed with Brooke. And everything was going along until Don gets arrested and he's going to go to prison. And in the federal system, if you have there's a bunch of categories about criminal cases in the federal system that reduce your time. One of those is if you are the sole caretaker for a child. Okay, that's a factor. Okay, no, there was no legally granted custody. It was their situation. It was the way they were doing it. This Brooke was actually sending the daughter to private school in Charleston. Okay, so she was raising her. She had her in school. Donald was nowhere to be seen until he realizes this is a factor that may help his sentencing, and he gets involved. Right now, he's like, "Wait, I want custody of this kid because it's my kid, first of all, right? And second, because he wants the benefit of at least that's what comes out." Is that he wants the benefit of saying he's the sole caretaker. Yeah, he didn't want to spend as much time in jail. So what's Brooke B do? Then they get into this is the best thing about Justice Ketchum is like he's the best writer in terms of these I don't know, he just says things. And he'll do this when he asks questions in court, which is kind of fun to see too. But he starts this, and this is an important thing, and I think you were raised up there, but since the founding of our state, the court has abided by the principle that issues of child custody revolve around the best interest of the child. This appeal demonstrates what happens when sight is lost of that Polish thought principle. I just think that's about as cut and dry of a statement as you can make about, how this is going to end up, right? Once you read that and then you read the facts, you know where this is going.
Seems like the majority of the case was not necessarily argued about who should have custody, but rather the venue that the trial should take place.
Right. So really, the whole thing isn't whether or not Brooke's the better mom or the better caretaker or guardian, whatever you want to call him. That isn't even hardly an issue, right? It's all procedural. They jump between 3 county courts. They're in 3 different counties. She files a petition, and I always forget.
It was Kanawha.
Yeah, I think she was in Kanawha. He was originally in Preston, which is what, in the Kanawha Valley? Isn't that in Kanawha Valley something?
Yeah.
And then he's from Boone, so he takes the kid. This is the irony of it. He takes the kid to his parents' house in Boone because he's not taking care of her for a period of time. His mother is. Okay? Another factor that comes in, he moves to Boone, claims he's living in Boone because that's his address. Remember, he's selling all his stuff because he owes all this money because he got caught for embezzlement or something, and he's going to go to prison. He knows he's going for some time. The kid's getting bounced around. By the way, the only mom this kid ever knew is Brooke, and now she's living with grandma in Boone County, which is nothing wrong with living with grandma, but she didn't really, there's no indication she didn't know grandma and grandpa, but she is living with Brooke. She's out of her school, the whole thing, and it's all procedural now. We're talking about where's the venue? Where should you go? What's the jurisdiction? Okay, so the court comes out, and the whole thing comes down to what? Is she a psychological parent, and does the statutory scheme allow psychological parents to have standing to come in court and seek guardianship, right? But because of the first 2 sentences in this whole thing, you know the answer. The court's going to find that she can take custody, and they do, right? Except that they don't grant that. I wanted to point out one other thing that's interesting about this case. Okay, I'm going to go to the very end just so you know. The court is going to grant. They make it fairly clear that Justice Ketchum, in the opinions, that basically is telling the lower court that you're going to have a hearing on guardianship, and you dang well better give it to her, to Brooke, because otherwise we're going to be right back here again, right? And oh, by the way, mom biological mother does show up in the case only to say, Brooke's the right place to be, right? So that's a good sign.
She made it clear she didn't want custody or something.
Yeah, well, that makes it sound a little harsher, doesn't it?
Yeah.
But she made it clear, I'm not here because I'm one in on this. I'm here to say that that jerk Don doesn't get custody, right? I mean, it kind of sounds like that's why she shows up. Or she's less happy, and which I've seen that before. Parents get drug into court and they're like, why am I here? I don't know the kid. I mean, I have seen that. But anyway. So the thing goes in and the court says they should quickly resolve the questions. The court, by the way, the Supreme Court rarely says, like, quickly get this done, move on, this kid needs to move on. They rarely do that. They say, you know, resolve these questions, have the hearing in Kanawha County, be done with it. If so, expeditiously resolve the shared parenting and gardening issues raised by Brooke's motion, take all that up. Then at the very end, what happens normally in a Supreme Court case when they issue an opinion is that it goes out for a 30-day period when you can file what they call a motion for a rehearing. So the opinion's issued, the lawyers now and the parties know what is the status of the case, and they kick it back out, and they say, to give you an opportunity for 30 days to rehear it and say, you've read it, do we miss something? And they'll make a motion to rehear. When they do that, it can be reheard, or if no one files a motion, or at least the motion isn't granted in the 30 days, they then issue by separate order something called a mandate, which now directs the lower court that you actually do the work now. In this case, look what the court does. It says, finally, the clerk of the circuit of this court, okay, the Supreme Court clerk, is directed to issue the mandate forthwith. What do you think that means? Yeah, we're not waiting 30 days. You're doing it now. The mandate's out. Court, you can have the hearing now. Normally, the court would be without jurisdiction for 30 days to do anything, because when a case is on appeal, the lower court loses jurisdiction, okay? But with this is a rare thing the court will almost never do, is say, mandate is issued forthwith. That means it's right now. We aren't going to send you on. In the future, they might put a separate thing and attach it together, but that 30-day rehearing, we're not rehearing it. We decided, the game over. Court, go ahead and resolve this kid's issue. Okay? They are more likely to do it in a kid's case because time flies for kids. 1 month, that's a long time for a kid. Okay? So we got all that? Any questions about the case that you want to raise? I'm impressed it's still up there. Okay. I better pull up something else. What was the other thing I was going to talk about today? Any questions? Anyone have a question? Oh, they're back. Uh-oh. Whenever I do that, somebody takes over for a minute. Okay. Any questions? No? All right. So let's move on briefly. I don't want to belabor what you can read about child support, but you know that even without a divorce, we have a case. We can have the child custody arrangements. We can also have the sorry, I'm trying to mute that one. Okay. We can still have a case on child custody. We can still have a case on child support. We still have all those other issues that we can do even without a divorce. Typically, those are the rules come through the divorce process. That's how normally and historically we talked about all those things. But we still have this issue. It's really its own thing. Remember, I talked about that's the divorce. The divorce gets granted early on, and then the fight starts. Well, the other things we talked about before we got to child custody, which was last time, and then that case we just talked about, the Brooke B. versus Donald Ray, that's child custody that can occur without the divorce. But really, you're not going to have spousal support. You're not going to have property division without a divorce. But when we get into child support, it is without a divorce. Okay, you can have those things. So really, it's usually one of the larger areas. The bigger area, more than anything else, has to do with the custody arrangement. What is the timing? What does all that have to do with how we determine who gets the lion's share of the custody? And then part of who gets the custody relates to how much has to be paid in child support. Okay, and we're going to talk a little bit about that. But over time, what we used to have, and this used to be a buzzword, I don't know, I think we still hear it from time to time, is the deadbeat dad law. You know, right? You've heard of deadbeat dads. That was a big push really in the 90s and early 2000s about we're going to do something about the deadbeat dads. What are deadbeat dads, according to that thought process? One, dads that either, sometimes we consider them to be ones that never visited with their kids, but really what it meant was the people who don't pay child support. Okay, so what did we do about that? We created things known as child support enforcement. Okay, I think that's under title, it's right there, 4D. It's a federal law, and IDD, you'll see it written as. And it has to do with the federal guidelines for providing what I think they're called TANF benefits. Okay, is that right? Yeah, I think that's it. You know, like support services and benefits to families. In order to get that money from the federal level, all the states had to create a child support enforcement agency. In West Virginia, we call it the Bureau of Child Support Enforcement. You'll hear it shortened to BCSE. Okay, they have lawyers and people that work there, and their lawyers spend most of their days, guess where? In family court, right? Arguing for child support orders and making sure the calculations get done right when the judges are doing them. And they also, guess what? BCSE stands for enforcement. They enforce support orders. So they're in family court raising those things to try to get collection. Okay, that's what is in West Virginia. In Ohio, it's called the Child Support Enforcement Agency, the CSEA. Okay, they all pretty much have child support enforcement in there. The BCSE and SCEA also, they'll collect spousal support payments, by the way, and distribute them. Okay, so what they do as a general rule, the idea was that they were wanting to eliminate what we call arrearages. Okay, what's an arrearage?
I know it's an amount that collects over time throughout the child support.
Right, so in other words, so let's say a child's 5 years old today, or 10 years ago, a child was 5 years old when the parents got divorced. Okay, there was a child support order entered. And from age 5 to age now 15, we're 10 years later, over that time, the person that needed to pay paid sporadically, let's say. Okay, so over time, let's say they were ordered $200 a month and they paid, when they could, they paid $200 a month. And that was about half the time. In 10 years, that adds up, right? And it's the amount that was never paid that's still owed. Okay, meanwhile, today, because the child's 15, there's still 3 more years of their life, right? Or until their age of majority. Okay, their invincibility period begins at 18, and then I don't know where I was going there. Age of their minority, when they hit age 18, there's still 3 more years, okay? So there's a continuing $200 a month due for the next 3 years, right? Plus, there's the sporadic payments that are missing for the last 10. That's the arrearage part. And realize there's a continuing order going forward.
But what's the point in arrearage if they just write it off?
If they just write it off, the parent or the bureau?
The Bureau.
Okay, so the basis for it is, okay, here's what happens. If a parent is not paying their child support, they're ordered to, they don't pay it. There are different ways to avoid having to pay. None of them are totally legitimate, by the way. You know, one of the ways you can get a zero support order for a period of time is if you were, you know, unwillingly unemployed. A lot of times you can, like, you know, you got fired or you can't find a job even though you're trying. you can get to where you get a $0 support obligation for a period of time. In any event, low-income folks are entitled to support from the government assistance, right? So when you ask, what are they going to do if they're going to write off? The state theoretically writes it off. But part of the federal, it comes from the federal money. Federal money goes into the state to pay those public assistance benefits, right? And that money is paid to the people to help support. In the meantime, part of that IVD ruling from the law in the federal government is that in order to collect that federal funds, you have to try to collect those arrearages over time. Okay, does that make sense? So the states have a requirement to try to eliminate those back child support payments. So that's the point of it. That makes sense? So in the old days, we used to just let it go. Okay, let's go with that. Okay, whatever. The state took care of you. Now you're an adult. Now do you need the money anymore? That's a good point, right? You made it. But is that fair?
Been there, done that.
Right? So that's the factor that's playing in there. So the federal, I think it's a good law, and what it said was we're going to come after you for it. We're requiring the deadbeat dads to pay the arrearages. Are they always dads? They are not. It can be both. And actually, there's a support obligation if you have lost custodial rights. Okay, if you haven't lost your parental rights, just your custodial rights, you still have an obligation to pay into the system for your child support payment. Confusing part of the abuse and neglect law sometimes, but in any event, you have to pay over time. So that's what the whole point is. That's what child support enforcement agencies are all about, and they have all those things out there. Okay, so who has to pay child support? I think we know this pretty clearly. It's parents, right? Biological parents. There are obligor. There's some language that you'll get in there. People that have to do with who's obligated, who gets the money. Okay, typically the custodial parent or the one who's entitled to the support payment. Realize, I think I mentioned to you that really truthfully, child support is owned by the child, not the parent. So the parent cannot waive it, okay, under the Child Support Enforcement Agency rules and all those things. But an obligor is someone who has to pay, an obligee is the one who receives it. Pay or payee is the same definition. If you adopt a kid, okay, what we see kind of regularly from time to time in adoptions is that you have a step-parent adoption. So a parent, there's a biological parent, and then subsequent, there's a divorce, or there was never a marriage originally. There's a remarriage or a marriage to someone else who is raising the child. Okay, you could have had it in the Brooke B case. Brooke B could have married Donald and then adopted his daughter as a stepdaughter. Now she would become her legal daughter. Okay, and then if they would have split up and Don would have kept custody, she would have had to pay child support. Okay, because once you become adoptive parent, you are now the parent legally. You have those obligations. There's some other questions about whether or not grandparents and step-parents have to pay child support. Typically, no. The general rule is that if, let's say, your parent remarries, in my case, my parents did, both of them did. My mom remarried, my stepdad, if they were to split up, would my stepdad have to pay child support? No, he wouldn't, okay? However, there's another little thing, and it's a Latin phrase, in loco parentis. We use it sometimes with the schools, okay, to support corporal punishment. I don't know if you knew that part. But in loco parentis, what does that mean? In the position of a parent, basically, the location of a parent. Sometimes step-parents can be in loco parentis, okay? So interestingly, of course, I'm going to assign you another case to read, and it's going to be about a case involving a step-parent and child support payments. So you can see a little bit of an example of how that plays out. Okay, so those have happened. Typically, we would say that step-parents are not obligated because it's not there. There's probably another, the general rule is there's another parent, there's a biological parent that has the obligation to pay. We have some confusing situations because in this area, we assume that if you're on the birth certificate, you're the parent, okay? You would have the obligation. If your spouse, if your wife, for instance, has a child, when you're married to her, it's assumed it's your child, even if it's not, right? So you can biologically not be your kid, right? But the law assumes that a child born within a marriage is a child of the marriage. That can be confusing too, right? Okay, we see those kinds of things. Co-parenting, we have different factors there. Can that really play in? I don't know. That's a confusing one. There's some new law on that. We have sperm donors. Do they require to pay child support? Okay, just like a couple years ago, I'll give you an example. There was a kind of a strange case that came out. I think it was in Tennessee, and a lesbian couple wanted to conceive, but they didn't want to go to the formal route of a sperm bank and in vitro or whatever some other different way of conception. So they did it. They made a deal with this guy, and they paid him some money, and then they were just going to do it the old-fashioned way. It was cheaper, right? Okay, makes sense, right? Instead of going to the doctor, it costs a lot of money. They just pay him, like, instead of paying $30,000, they're going to pay him $5,000 or something, right? And they were going to make a deal.
What's the point of the relationship?
So they made a deal with him that then he would waive, as part of that, he would waive all his parental rights, and he would waive his responsibility to pay any child support in the future, right? Makes sense. It's a deal. He's making it, okay? What happens is those folks, the couple, they go on about their being married and raising the kid, and the state finds out that they naturally conceived this child with this guy, and the state determines he's the dad, and he owes a duty of child support. Well, he didn't see that coming. Maybe he should have. But you can see the fiasco that could be created there, right? I mean, you'd be like, well, they made you do it. I mean, I shouldn't have to pay. The courts determined that only if you go through the official process, essentially like an adoption, of using a sperm bank and using it in the medical way as opposed to the old-fashioned way, right? That you can't be relieved of your child support obligation. Okay? So that's a confusing way to think about it, but you can imagine that's happened, right? Many people have probably done that throughout time, and for that matter. I'm sure there's Lifetime movies on that. Anyway, it is what it is. But if your sperm donor is required to pay child support unless it's gone through the official medical process, the legal process for that. And that there's a reason. We want to encourage you to do it through the legal process because it could get really complicated. Okay? So, any questions about that? Moving on. How long do you have to pay? Well, there was some thought process, and you maybe think colloquially that that child support's paid until you're done with college, or there's a requirement to pay for college, that kind of stuff. That's not the law. The law is you are responsible until the age of majority, or unless you're emancipated. Okay? So what's the age of majority? It's 18. So at age 18, you're relieved of your child support obligation. Okay? Or if you're emancipated, what's it mean to be emancipated?
If you're under the age of 18, but you're legally separated from your parents.
Right. So you're under age 18. You actually legally get separated by your parents through a court order, right? Okay. However, in most states, the age of majority is not the cutoff. It's actually age of majority or high school graduation, whichever is later. So a lot of people in their senior year of high school turn age 18, right? And some people turn age 18 before they start their senior year of high school. And the obligation continues until you graduate. Okay, that doesn't mean that the kid could perpetually not graduate, I suppose.
Have Billy Madison.
Right, there's Billy Madison. I guess he was still on child support, and he was certainly under parental support, right? Yeah. Oh, the penguin. Okay.
Nudie Magazine did.
So actually, it goes on a little bit longer than age just 18 for most folks. And that's definitely the law in West Virginia, and really that's the law in Ohio. Actually, the case that established that in West Virginia was a Wood County case, where it was kind of interesting. The guy took it all the way up that he shouldn't have to pay throughout college and everything. So anyway, but there's no legal obligation to pay for college. There's probably maybe a moral obligation to pay for college, but it's not generally legal. You can always make a deal throughout the thing. Back to school. Okay, disability. Sometimes that obligation can continue if there's a disability that basically the child remains like adjudicated in some way where they need a legal guardian. That can continue on. You'll see that sometimes. If you ever have an obligation before birth, I don't know. There's been some wild cases about the expansion of the law in that area. So do you have to pay child support for birth, or do you have to pay for the process? Well, when you get into the surrogates and some of that stuff, there is some obligation, right? Probably not in the family law arena, but in the contractual arrangement arena, right? The problem is historically we've said that would be a legal subject matter, right? To have a contract for surrogate or whatever, but we've allowed that as a specialized exception. Could you pay a lump sum of child support? I suppose you could. There's no real reason you couldn't do that. Sometimes you see, and we're going to talk about that here in a second, about how you determine how much there is, how much you have to pay, but you could have a lump sum. Anyway, you get that idea. So how much is there? In every state, there is some particular guidelines that are provided in terms of determining the amount of child support. Typically, most states use what we know as the income shares formula. The income shares formula is very simple, and I'm going to send you out to do an assignment on that too. So I'm going to give you the case. I'm going to give you an assignment on income shares, and ask you a couple of questions about what is the income shares formula, what is the real dispute in that area. But the income shares basically combines the income of both parents into one huge total, okay? Puts it together, adds them together, and then as part of that, it calculates what percentage of the whole is each parent's, okay? It'll equal 100%. For most people, you'll see somewhere around 50-50, but it could be anywhere from 45, 65, or different calculation, or 55, 45, 55, okay, whatever. 60, 40, you'll have different ones. It's just literally count the numbers and give which percentage are you of each one. And then you take that whole number and you put it in the chart, and it's a number of kids, and then there's a number in the statute. And the statute tells you exactly how much the total child support obligation should be at 100%. Then it takes the percentage that each parent has and says, your obligation, let's say the child support obligation total is $1,000. And it determines that mom has to pay 60% and dad has to pay 40%. It would then order $1,000 and say mom's obligation is to pay $600, okay, to dad to make up the difference in the support. You'll see what that means when I put you out for the assignment to work on that. But that's the income shares formula. Basically, it says it follows the old rule that we always followed in this, and that is that after a divorce, the child is entitled to the benefits of the family unit had it remained together. So in other words, what does that mean? It means that if mom or dad continue to make, whatever income they make should come back to the child's household, wherever that household is, right? So you should roughly have the same amount of support that you would have if the parents hadn't been split up. Okay, that makes sense? So if it was one single, that's the concept for what income shares are. Percentage of income roughly follows that same principle, but all he does is calculate one side's thing and says you owe how much percentage of that. A lot of states, not many states are using that anymore. Income share seems to come out as the main way to do it. We have something known as the three-pony rule. Okay, what is the three-pony rule? Anybody ever seen that before? Basically, it says that kids are only entitled to 3 ponies. Okay? What do you think that means? The old rule was that is, no child, no matter how wealthy the parents, needs to be provided more than 3 ponies. What? Yeah, no more than 3 iPads or no more than 1 Disney trip a year or whatever. Right? You get the idea. The idea is that at some point, you don't just have to keep calculating child support. Kids don't need that much money to survive on their own, right? So that it shouldn't be that I am putting the money over the other side. So a kid only needs so much support. There's some limit to how much is actually needed for the child, right? In particularly wealthy families. That's the concept. So what we find in those kinds of cases actually is some breakdown that some percentage of this is child support that's paid on a monthly basis to the custodial parent, and some other portion of it actually goes to a trust or some other place to support the child later in life. So that it's invested so the child gets to share in that relationship, that the income of both parties, but that one is put in really into a savings plan for later in life. Does that make sense? Kind of an interesting thing, but it's a rule that says that children don't have an entitlement to this richy rich lifestyle, right? I mean, that's the idea. Second family has to do with whether or not you take into account a first child support obligation. You know, a lot of times people have child support obligations arising out of more than one relationship, and you actually, the first child's income, or I mean, the income shares formula gets the full benefit of both numbers. If the second child support obligation actually will be reduced in some way based on the fact that there's another family there, okay? You do take into account the fact that you're trying to make sure to not like bankrupt 2 families, you know, that's the other factor. Sometimes related to the wealthy family stuff is imputed income, that if essentially you're trying to use child support to skirt around the spousal support tax rules, that will actually say that that's income to the parent, okay? All right, there's some other factors about how do they actually enforce child support orders and all that stuff. I already talked a lot about what the IVD rules, the federal level. There's new hire reporting. So whenever you hire somebody, it's put into a database where that these child support agencies have a federal database. They know whenever someone is legally employed, they get a ding, okay, to help locate missing parents, locate these folks and go after them and find them so that they can actually be made responsible for their child support payments. We have paternity testing that happens in the child support enforcement areas. They'll go and they do all that process and determine and establish paternity. How do they enforce it? They can do it by contempt. Contempt is where we basically throw you in jail for not paying child support. That was a big thing under the deadbeat dad laws, was to put people in jail for it. You have to be in what they call willful and contumacious contempt. What does that mean? It means that I have an ability to pay and I'm just refusing to pay, okay? It can't be that I don't have it. You can't like put somebody in jail because they don't have it. You'll see that argument made from time to time when someone does have the ability to pay and they aren't. They're like, it's really debtor's jail, and that got outlawed as unconstitutional at one time. You can't put people in jail because they have debt. We used to do that, okay? We then created laws that said that non-support of your children is actually a crime. We have execution. That sounds terrible, right? We'll just kill you. Like, you didn't pay, I kill you now. No, you can execute on their assets is what that means. The common one is income withholding. So you can actually go and every month your employer actually kicks the money to child support enforcement. You have garnishment that works the opposite way. So that's usually the non-willful version of withholding. That's when the government actually goes out and will attach your wages and take it, okay? We can deny your license and registration for your vehicles and your driver's license. We won't let you have a passport. A common one you'll see every year around this time as we get into full into tax season is that they do what are known as tax refund intercepts. And they just go in, and when you get a refund, they say, oh, thank you, we'll take all of that, right? They take it all, as long as it's not like over the amount that's owed. They just literally go in. Okay, all of these things give you some ideas about how you can avoid paying taxes, I think, or paying your child support. They'll take it out of a quadro. They'll take it from unemployment workers' comp benefits. They'll freeze and seize your bank accounts. They can put liens on your property. And then a common one that came out during the deadbeat era, that was really big. I know time's up. I'm getting through it. Wanted posters. This was when you actually put it at the post office that this person isn't paying their support and we should shun them and shame them, right? That was the concept. All right, so wrapping all that up, I want to hit like one other thing. We sometimes have them in DV orders, but lastly, we have what are known as modification of child support. You get the ability to change it over time. Just one time it being set isn't enough, but we can only modify it for substantial change in circumstances. I ask you generally, what constitutes a substantial change in circumstances? I'll ask that in a quiz question, or I'm not a quiz. I'll put that in an assignment so you can look that up because actually it's the law. Let me see. Okay, so that's all. That's basically the end of what I had to tell you about all that. And I'm going to give you those couple of signs. I'm going to give you a case, talks about disestablishment of paternity and child support. Let's go with I forgot about the attendance word. That's a bummer. Let's go, I hate to put it at the end. Let's say it's disestablish. That's the attendance word. Disestablish. If you're not here and if you are here and typing, I'll just mark you as attending. Okay. So look for your assignment to come out here shortly, and I will see you next time.